Ron? Where are you? Where is Ron right now? You done messed up, Ron!
Everyone, sorry for the late start. I could not get my normal camera to connect to my computer the way that I normally would. So if my camera quality looks a bit different, or if I'm crooked here, that's the reason. Guys, I got some wild stuff for you tonight. Absolutely wild. I have this video monetization turned off so that we can speak frankly and not pussyfoot around the subject at hand. This is absolutely incredible that this has not come up before now. The jury foreman in the Danny Masterson trial had a massive undisclosed conflict that if it had been revealed during the trial, he would have been immediately dismissed. And this conflict, and I'm going to tell you all about it, calls into question everything he has said publicly since the trial ended. It calls into question his motivations. It calls into question a whole lot of things. And it also calls into question whether he was actually working in coordination with the defense team to put out propaganda about the trial in an effort to have the charges thrown out. And let's get right into it, guys. So here is, well, actually, this all starts with an article that was run last week in LA Magazine, where the author linked to the defense, a copy of the defense's motion to dismiss the charges. And that, you know, right here, she hyperlinks to the motion for defense. People complain that they can't see the mouse. On this MacBook here, if I wiggle the mouse around real big, it gets big like that. And so hopefully you can see that. Okay, so if you click on that link, it brings you to the motion itself. And I'll make this bigger for you guys. Let's see. I'm showing you the research trail here, how this information came to light. Okay. You see, this is an 85-page motion. Okay, 85 pages. Way down on page 83, we see Exhibit 2, an actual declaration submitted by the jury foreman, a declaration completed for Philip Cohen, the defense attorney, stating, in my opinion, based on the credibility issues with the Jane Does, it is very unlikely that 12 jurors will ever unanimously agree to find Mr. Masterson guilty of any of the charges. The focus of our deliberation was on the statements and testimony of the Jane Does, and that evidence raised too many credibility concerns and too much doubt for me to think any reasonable jury will ever unanimously convict. I certify under penalty of perjury, Okay, so I'm explaining to you that this affidavit was included in the filing because this is how, for the first time, the jury foreman's identity was revealed by the defense team. And I know this is hard to read for you guys on screen. Believe me, it's equally hard to read not on screen. Earl Batiste is the name of the juror. And you have to wonder, okay, so here we have Earl Batiste. Those are his parents up there. But here we have Earl Batiste. In his younger years, he was in the armed services. Okay. So what's the conflict? Let me remind everybody that Earl Batiste, by the way, I'm going to do my best not to ignore super chats. I see one there. So I want to catch it. For your media liability insurance. Oh, I appreciate that. My media liability insurance is my ability to crowdfund as needed on my YouTube channel, hopefully. Thank you, Jessica, though. I'll tuck that away into the media liability fund. Much appreciated. Okay, let me remind everybody that Earl Batiste was the jury foreman on a trial involving a sex offender, a potential sex offender. Danny Masterson is a Scientologist sex offender. He rapes women. He drugs women and rapes women. So you have an actor sex offender. Well, let me introduce you to Earl Batiste II, Earl Batiste's son. I know this is probably hard to read, but I'll explain to you what you're looking at here. What you are seeing is that Earl Batiste II is a registered sex offender, was successfully prosecuted by the LA District Attorney Office for lewd and indecent proposal and / acts to children. He's a sex offender for crimes against children. Earl Batiste, the jury foreman in the Masterson case, his own son was prosecuted successfully for sex offenses by the same frickin' district attorney office that was prosecuting Danny Masterson. How in the world this was not disclosed is anybody's guess. Now you could say, wait, how do you know it wasn't disclosed? You didn't see the jurors' questionnaires, and you're correct. I suspect we're going to find out pretty soon, guys, that this was not disclosed. Perhaps it was. Perhaps it was. That's why my original title for this video was Jury Foreman in Masterson Trial Had Undisclosed Conflict, but I wanted to be a little bit careful. Maybe he did disclose it and the deputy DA just missed it. I'm saying that there's no way in hell that happened, guys. There's no way in hell Earl Batiste wrote down on his questionnaire, my son is a registered sex offender. And by the way, it gets a little better. I'll keep it in sequence here. Here you can see some screenshots directly from one of the terminals in the courthouse at the LA District County Courthouse regarding the case of Earl Batiste Jr. Filing date, you got a case number. Actually, before we continue, let me just make sure my correct microphone is working here because last time it wasn't. Okay, good. Looks like we're good. Okay, Steven Stout, I agree with your YouTube. I emailed you. However, again, I will ask, yes, the Church of Scientology say they do no wrong. One questions, why does someone not just get this stuff on video? They get thousands of hours, then get them to say they did not do X. I'm terribly sorry, Stephen. I do not understand the question. So I apologize. I just don't understand the question. Okay, you have screenshots here about the case. Okay, that's one screenshot. That's another screenshot. Register as a convicted sex offender, carry proof of registration at all times, display registration to any law enforcement officer upon request. Okay, protective order, Yeah, so Earl's son has to register as a sex offender for the rest of his life. And Earl Batiste III. So Earl Jr. has a son, and he does appear to be an aspiring actor, if not even a working actor. I just honestly can't quite tell. I don't see any credits for him. But if you do your own Google searching, there is a footprint that does indicate Earl's son is either an actor or an aspiring actor. How in the world does a juror on a case regarding a sex offending actor have one son who's a sex offender and another son who's an actor, and that's not a problem? I think that's a problem. And one has to wonder whether Philip Cohen, the defense attorney, already knew about this. And I'm going to show you a couple quotes that are also a bit troubling directly from the trial itself. So very early on in the trial, during the jury selection process, during the process I like to call voir dire, but other people call voir dire, the deputy DA and the juror that ended up being the foreman, Earl Batiste, they didn't get on very well. And I want to read for you a quote back and forth between the two of them. Winning. Okay. Juror number 30, which is ended up being Earl. Juror 30, I know you work at TSA. Do you have any issue with that? That wasn't the quote I was looking for. Come on now. Juror 30, you work for the government. Do you think a prosecutor has more credibility than a defense attorney? No, sir, I do not. I think both teams are trying to win. Okay. Now let's go. Let's see what Mr. Mueller had to say about some of the statements that Earl Batiste had to say about teams and trying to win. Okay, Mueller goes, Deputy DA Mueller says, I recently learned, sorry guys. He goes, I want to bring up one thing Mr. Cohen had touched on with some questions and response about both teams wanting to win. This is not about teams. This is not a sporting event. The one word I didn't hear was justice. What you all are here for is to ensure this is a fair and impartial process so justice can result. Both sides have rights. Mr. Masterson has his rights. The named victims, they have their rights. We're here to find justice. This is not about winning or losing or teams. So Earl Batiste, very early on in this trial, kind of got his hands smacked by Deputy DA Mueller. And it also gave us a little bit of a glimpse into Earl's mindset. Teams, winning. Didn't talk about justice. Now, what team would Earl be on if he has a son who was successfully prosecuted by the same DA office that was now prosecuting Danny Masterson? If Earl is thinking about this in terms of teams and winning and losing, which one of those teams do you suspect Earl might consider himself to be on? Okay, I see another comment here. Why can't some member get David Miscavige on video slapping someone or doing bad things? Why is it so difficult? Well, Stephen, there are reasons why it's difficult, but not impossible. But I'll tell you, no prosecutor in the United States gives a damn about Miscavige smacking somebody upside the head 20 years ago. So that's the simple answer to your question. But for questions on this particular video, I would ask, let's please just try to keep them on the topic at hand, because I do want to answer the super chats, but I also want to keep this particular stream on topic. Much appreciated, though. Okay, so now later on in Cohen's closing statements, I'm going to search for the word boys. Okay, this is Cohen's closing statements. You really have to wonder whether Cohen knew what was going on with Earl Batiste, what his family situation was like. Cohen goes, I didn't get married until later in life, did get married, had kids, and it did change my view, but it didn't. Okay. Cohen goes, I look at my boys, and I think one day they're going to be sitting in a chair like that, and our government is going to put on a case like this one was put on and hide from, ignore, avoid contradictions, the absolute fabrications from a jury, and one of my boys is going to be sitting there, and I won't be able to help. That's horrifying for me. Are you fucking kidding me? It's just a coincidence that one of the 12 jurors sitting in front of him literally had his son in that chair, who was found guilty, who probably felt there was nothing he could do. Cohen said all that and didn't know. Maybe he didn't know. I'm not saying he did, but I am saying it sure makes one wonder. Okay. So let's see here. There was an interview that Tony Ortega conducted with Earl Batiste on December 8th. This interview was done on Chris Shelton's YouTube channel, but Tony Ortega really conducted the interview. And if you had to summarize the entire interview into just a sentence or two, Earl Batiste was essentially saying, yeah, we didn't believe the Jane Does. They weren't credible. They had conflicting statements here, conflicting statements there, evidence here that didn't match with evidence there. They talked to each other. And he was really making the case for, we really considered, this. We really considered the facts in this case carefully. We were not influenced by any external influences, not Scientology. We're not intimidated. We're not scared. We're not afraid or whatever. And Tony took a lot of heat at the time for doing this interview, because some people wondered, why in the world would you do an interview before the district attorney had announced whether to retry the case, where the propaganda in the interview is essentially, yeah, the Jane Does weren't believable. When the jury foreman is only speaking for himself, obviously. He doesn't speak for the jury. The jury didn't acquit Danny Masterson. And so Tony Ortega's response to that criticism, thank you, Lenny, that's very generous of you. Tony Ortega's response to that criticism was, whoa. Earl did say in this interview that the DA could have done a better job, that he could have changed some things about his presentation, and it would have had a significant impact on the jury and the jury's how the jury took some things. Do we know yet what the implications of this are for the case going forward? We don't yet, but I suspect that we will soon. Now, the next argument that I would like to make here, let's go back to this affidavit. Guys, if Earl's intention, if Earl's was motivated by simply seeking justice, and if Earl really believed that the deputy DA could have improved some things and done things differently that would have had a better impact, then why wouldn't Earl just want the deputy DA to have another crack at this and have another opportunity to see if the system works? I guess there will be some that will be like, well, the system does work if he's innocent. I mean, if he thinks the deputy DA could have done a better job, why wouldn't he want the deputy DA to have another crack at this? There's a lot that we need to discuss about what it means that this affidavit from Earl even exists. Okay. And one thing to consider, hold on, I do have some notes that I'm going to refer to here. One thing to consider here is that the defense attorneys and the prosecutors have no idea what the real identities of the jurors are. Okay. So once the trial is over, it's actually an ethical violation. They are not even allowed to Google these people and try to find out who they are and try to reach out to them. Do they probably do that anyway? Sure. Are they allowed to? No. The fact that this affidavit even exists indicates it was Earl himself who went to the defense and offered to help them put this motion together to get the charges dismissed. Okay. Now you might go, well, maybe he just offered to consult, and maybe he also went to the DA's office and offered to consult there as well. Guys, I think we're going to find out pretty soon that Earl did not approach anybody in the DA's office. He did not offer any advice to the DA after the fact on this or that, beyond the meeting that they had in the courtroom right after the trial ended. The fact that Earl would put an affidavit together and say, in my opinion, no other jury would ever have a consensus, what's the word he used? Unanimously agree to convict Masterson. Who gives a shit what you think, Earl? What the hell does that have to do with anything? I thought you were just interested in justice, in making sure that the process worked. And I guess what I mean, yeah, the process worked. The DA had a chance to put on the best case possible, while Masterson would put on the best defense possible. I see a comment here. Do you think the DA needs to look into Earl's financials and the financials of his family for connections to Scientology for the defense? Anything's possible. That's not what I'm implying. I don't necessarily think Scientology had a role here, but I can't say that they didn't, obviously. Is Earl in Scientology's pocket? I don't have any evidence about that, and I'm not implying that. I don't even suspect it. Everything we're seeing here is, I think, explainable in other ways. But guys, I'm also saying that's just my opinion. Could he be in Scientology's pocket? Sure. Could he just be a man out for revenge for what happened to his son? I think that's more likely. Do you see where I'm going? Now, also, let's remember how, because also, I don't want to go back and forth. Sometimes this is why I keep notes. That's why I keep notes, guys, to keep my thoughts organized. Remember, Philip Cohen used Earl's affidavit as the evidence, as the basis to ask for the charges to be thrown out. But how did the defense get in touch with Earl? If you are familiar, and you probably aren't, with the story of how Tony Ortega came to get this interview with Earl in the first place. It had to do, Chris Shelton said that Earl's daughter reached out to Chris and said, Chris, I'm such a big fan of yours. I'm going to talk my father into doing an interview with you. Now, guys, let's just talk statistics here, okay? This is Chris Shelton's YouTube channel. His latest videos, and I'm just rounding to the nearest, I'm not rounding, I'm just going to cite the nearest large number before the decimal. 1,000 views, 2,000 views, 1,000 views, 2,000 views, 2,000, 3,000, 15,000, 9,000, 10,000, 2,000, 1,000, 5,000. Let's look at the live streams. 1,000 views, 1,000, 1,000, 1,000, 1,000, 1,000, 2,000. Guys, what is the statistical likelihood that a young Black woman in Los Angeles just happens to be a fan of Chris Shelton and her father happened to be selected for the Masterson jury? I'm not saying it's impossible. I'm saying it's incredibly unlikely. Now, unless this, I mean, it doesn't quite add up. Okay. So if you have, hold on, I'm getting my little things here. So I keep going back to this affidavit because this is in the motion to dismiss. You have 3 events for which we know the dates, and then you have 1 general event for which we don't know the dates, okay? There's whenever Earl's daughter, I guess I should change the view on this so you're at least kind of looking at me. Okay, so here's what we need to consider. You guys can walk through me with this, walk through this with me. We have this affidavit from Earl. And the affidavit at the bottom says, this affidavit has been executed on blank December 2022. They left the date blank, but they said December. Okay, so we have one date here. This was in December. When was Tony Ortega's interview with Earl Batiste? It was December 8th. Okay. So we have December 8th was the interview. This affidavit was originally executed in December. We don't actually know whether it was executed before the interview or after the interview. It doesn't necessarily matter. But we do have the date when they decided to actually sign it, and that's January 4th, just before they filed this whole motion in preparation for the hearing that was being held about whether the DA was going to retry the case. Okay. Here's what we don't know. Okay, so we have the date this affidavit was filled out. We have the date that the interview was conducted. The date that Earl's daughter reached out to Chris Shelton is known, although not to me. Here's what we don't know. When did Earl first approach the defense attorneys and offer his services to them to get the charges against Danny Masterson thrown out? Because I'm going to tell you what I suspect. Especially when we consider that the only evidence submitted in support of the motion to throw out the charges was Earl Baptiste's affidavit. And the affidavit and also what Earl said in the interview with Tony. Here's what I suspect. I suspect Earl approached Philip Cohen and his team and offered his services. Then I suspect that Philip Cohen came up with the strategy to have Earl approach Chris and Tony to do an interview. And then they arranged it, like do it through the daughter and make it look like it just happened organically. So that they could use the interview as the evidence that they needed to ask for the charges to be dismissed. And you go, Aaron, you can't prove that. No, I can't prove it. I'm saying that's what I suspect. These dots all fit together some way. We don't know exactly how they fit together, but this is one plausible way that they could fit together. that immediately calls into question the motivations and the truth behind everything Earl said in the interview with Tony, because it looks like when that interview occurred, Earl was likely already working for the defense. So Earl going on this interview and saying, we didn't believe Jane Doe 1 and Jane Doe 2 was a problem and Jane Doe 3. And it sort of seems like an innocent interview until you go, but wait a second. Why did he then go and offer to help the defense to get the charges thrown out? That doesn't make sense. That looks like he's taking sides, as opposed to just explaining what happened and saying, leave it to the next jury. Like, why does Earl care whether this case gets retried or not? How is that any of Earl's business? You would think that if he was being just fair and balanced and thought that the DA could have possibly done better, that when the defense team asked him to fill out this affidavit, he would have been like, no. I said my piece. I just wanted everyone to understand that we did a fair job. Maybe another jury would find differently. I'm not going to fill out this affidavit for you. And yet he did fill out the affidavit. So I suspect, now look, if Earl really did not disclose, if there was a question on the jury questionnaire asking about family members who were convicted felons or sex offenders or anything like this, and Earl didn't disclose that, I believe that is a felony. And if that is actually what happened, I wouldn't be surprised to see the DA's office actually pursue charges against Earl. I'm guessing that after all this information comes out, the DA's office will actually go back and review all the questionnaires and see if somehow there wasn't a question on the questionnaire that covered these subjects. That would be incredible, but possible. Is there any way that Earl did actually disclose this and it just sort of was missed? Unlikely, but possible. Until somebody goes back and double checks, we won't know. But if they go back and check and Earl really didn't disclose these things, I mean, is there some version of reality where there's more than one Earl Batiste and more than one Earl Batiste II and more than one Earl Batiste III and I've got it all wrong? Sure. We'll know soon enough. I don't think we live in that version of reality, but we'll know soon enough. And let me see if there's, I'm just looking at my notes here real quick. Okay, we covered that. Covered that. All right. We've kind of covered a lot, guys. Geez, we've been going for 27 minutes. Okay, no wonder we covered it all. Okay, so at the end of my videos, I tend to want to try to summarize everything I've already said in my video, and in this case, I'm not going to do that. I am dying to hear from you guys in the comments section down below. Let me know, what logical mistakes have I made? Because, I'm not doing this video to absolutely prove something. I'm doing this video to reveal information. This is part of the process. This is all part of the learning process. It's part of the conversation. The best way to find out you've made a mistake is to let everybody on YouTube know, let you know you've made the mistake. So it's the best learning process that there is for me. I did just see a comment here. What do we have? What if Scientology used their PIs to make contact with the juror? There's one thing that we've learned over and over again, which is never underestimate Scientology's ability to figure out how to come at you without you realizing that it's them coming at you. So I don't rule anything out, but that's not what I'm implying in this video. You know what I'm saying? So yeah, what am I missing? What am I missing, you guys? Where have I messed up on this? What are some other possible ways that these dots connect? I want to know specifically what you think about the possibility that the defense team literally orchestrated Earl doing this interview with Chris Shelton and Tony Ortega. That's what I'm very interested to know if you think I'm making a giant leap there. If Earl had not filled out an affidavit for the defense team saying no other reasonable jury could ever unanimously convict Danny Masterson, I wouldn't even be guessing that it was all a setup. But this document to me leads me to believe I see almost no other logical conclusion. So help me out, guys. What logical conclusion am I missing? All right, that's what I got. I think this is huge, huge news, and I'm dying to see what comes of this. All right, let me know what's going on in the comments down below, guys. I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.